Good morning, all, and this hearing is now called to order. I'll now read the decisions of the Commission in relation to some motions made yesterday. The first motion deals with a motion to expunge pages from the records of proceedings. The Watson-Simpson team complained about certain statements made by Mr. Allen to be found in lines 1657 to 1660 of the transcript for day 6 and lines 1627 to 1636 of the transcript for day 11, which she asked the Commission to expunge from the record. On 2 earlier occasions, the Commission had exhorted parties before it to be respectful to the Commission and other parties before the Commission. Otherwise, the parties have conducted themselves well before the Commission in these proceedings, for which they must be commended. The Commission has reviewed the statements complained of. The Commission does not think that the statements give rise to any innuendo or cast any aspersions on the reputation of Ms. Watson, or were disrespectful, or that the statements constitute any breach of any rules of practice. The Commission can find no basis for removing the statements from the record. Therefore, the Watson-Simpson team's motion for specific pages to be expunged from the record of the proceedings is refused. Motion to tender documents by affidavit. During this hearing, the Commission, on its own and at the request of various interveners, directed the Barbados Light and Power Company to produce various documents. Ms. Watson now asks the Commission to direct the Barbados Light and Power Company to tender in evidence by affidavit the various documents produced. There is a distinction between the case where the Commission directs the production of a document, either on its own or at the request of a party, and the case where the party wishes to tender a document in evidence as part of its case. In the latter case, the earlier procedural order of the Commission is that evidence is given by affidavit. Where the Commission directs the production of documents either on its own or at the request of an intervener, it does so to enable the Commission to obtain a full and satisfactory understanding of any issue in the proceedings. The documents directed to be produced are not being tendered by the Barbados Light and Power Company as evidence as part of its case, and therefore there is no requirement that documents be tendered in evidence by affidavit by the Barbados Light and Power Company. Therefore, the motion for the Barbados Light and Power Company to file an affidavit tendering evidence the various documents produced during this hearing is dismissed. Motion for the Barbados Light and Power Company to file a motion for confidentiality. The Commission asked Dr. Hanser to produce a model relied upon by him in producing his report, which he indicated was proprietary to the Brattle Group and only disclosed on the execution of a non-disclosure agreement. On re-examination by Mr. Allen, Dr. Hanser nevertheless indicated that he was agreeable to producing the model for the Commission only, on the basis that it is proprietary. The Watson-Simpson team now submits that the Barbados Light and Power Company should be required to make an application in the normal way for the document to be treated as confidential. We understand Ms. Watson wants the Commission to direct the Barbados Light and Power Company to make a written application for an order of confidentiality. At the time Dr. Hanser agreed to produce the model for the Commission only, none of the interveners objected. The model is not a document that the Barbados Light and Power Company sought to tender into evidence as part of its case. It would, in the view of the Commission, be highly anomalous to require the Barbados Light and Power Company to file an application for confidentiality concerning a document that it did not seek to produce as evidence in this case. Further, it would be unfair to have a document which may be the intellectual property of the Brattle Group to be disseminated to the interveners when the same was asked to be produced to the Commission only. The motion for the Commission to direct the Barbados Light and Power Company to file an application for confidentiality concerning Dr. Hans's model is refused. Motion to direct the Barbados Light and Power Company to answer interrogatories. Public Counsel and the Watson-Simpson have asked the Commission to direct the Barbados Light and Power Company to answer interrogatories, which they contend that the Barbados Light and Power Company has not answered or have not answered satisfactorily. The interrogatory process permits parties to obtain relevant information, documents, and admissions to narrow the points of dispute between the parties before the hearing. Thus, interrogatories serve the purpose of facilitating the expedition of the hearing and save time and costs. The motion was made on the penultimate day of the hearing, after 13 hearing days before the Commission has passed. At this moment in time, the Barbados Light and Power Company has closed its case. It would be unusual to order the Barbados Light and Power Company to answer interrogatories at this stage when its case has been closed. Any motion for the Commission to direct the Barbados Light and Power Company to answer any interrogatories could have been made earlier, setting out the grounds in support of the motion. In addition, during this lengthy hearing, the interveners exhaustively and repetitively interrogated the Barbados Light and Power Company's witnesses and requested the production of various documents. The Commission is satisfied that the interveners are unlikely to be prejudiced by the Barbados Light and Power Company's alleged refusal to answer fully or at all any interrogatories. Finally, the parties are at liberty to submit the adverse findings, if any, which the Commission should make consequent upon the Barbados Light and Power Company's alleged failure to answer satisfactorily or at all any pre-hearing interrogatory or any question put to a witness during the hearing. For these reasons, the motion to direct the Barbados Light and Power Company to answer any interrogatories is dismissed. Admission of the affidavit of Ralph Smith. Public Counsel has indicated that Mr. Ralph Smith will not be called as a witness to give live evidence and to be cross-examined on his affidavit. It appears that, nonetheless, she wishes the affidavit to be tendered in evidence. Mr. Allen seems not to object to its admission, but wishes to make submissions on the affidavit. The Commission will admit the affidavit of Mr. Ralph Smith and will allow parties to make submissions on the affidavit. The Commission, in considering the evidence of Mr. Ralph Smith, will give appropriate weight to the same, having regard to the fact that he did not appear as a witness to give live evidence, and his evidence, where disputed, was not tested under cross-examination. I now invite Mr. Allen to do his closing.
Thank you, Chair, and good morning. Chairman, during my opening statement, I would have highlighted the context in which the Barbados Light and Power Company Limited has made this application for rate review. Context includes, but is not limited to, a number of factors. Significantly depressed rates of return for a number of years, investments by the applicant of over $331 million in plant and equipment over the last 3 years, $750 million over the last 10, to ensure a high level of reliable service and grid resilience for the benefit of customers. The need to make further investments to facilitate the transition to 100% renewables by 2030, The oft-referenced and examined flat or negative sales, which are projected to generally continue in circumstances where expenses have and continue to significantly rise. The significant efforts over the last 10 years by the applicant to manage expenses, renegotiate debt, and increase efficiencies, which have resulted in the applicant's ability to extend the period between rate reviews beyond the typical 5 years or less. The statutory provisions under the URA, which impose an obligation on the Commission to set a fair and reasonable rate, taking into account a number of factors, as well as the statutory provisions which take regard to the necessity to ensure that an efficient service provider will be able to finance its functions by earning a reasonable return on capital. Notwithstanding the noise from some corners, it is objectively clear, and the evidence has shown, that the applicant has and continues to be an efficient service provider that has a long track record of providing safe and reliable service to its customer at low rates. This is evident from one, the benchmarking study, which is before this commission, and together with the evidence from Managing Director Roger Blackman, which reveals that the applicant rates are among the lowest in the region and in the bottom half on the scale of expense. The fact that the applicant has been able to negotiate its debt such that its average cost of debt is 2.78%, significantly below the central bank reported average. The fact that the basic rates for domestic service customer charges have increased less than 8% since 1983, well below and in contrast to inflation in triple digits over the same period in the economy. Investments in infrastructure, new equipment, grid modernization to meet evolving customer expectations, increased operational requirements, and transition to renewables. Such investments include the investment in the first and largest solar plant in the Eastern Caribbean, the Clean Energy Bridge, which has already had positive effect on customer bills, battery storage, grid modernization, cybersecurity, among other investments, good safety and safety reliability results, and limited outages. Through its witnesses, the applicant detailed its operations over the last 10 plus years. It has shown that it has been successful in its efforts to control costs in producing and distributing electricity, even in the context of those referenced flat sales. These efforts included a significant restructuring exercise to increase efficiencies, improve processes, and strategically align the business to allow for the implementation of government's renewable energy vision by 2030. The applicant has grown its rate base by over $250 million, disproving the lie that it has solely focused on profits to the detriment of the consumer. I need not to remind the Commission about the relevant statutory provisions which guides its conducts and the obvious import of sections 3 and 10 of the URA. But I would be remiss if I weren't to point out certain specific and guiding principles which must inform the Commission in its decision. In section 3.2, in establishing the principles referred to, the Commission shall have regard to the promotion of efficiency on the part of service providers, ensuring that an efficient service provider will be able to finance its functions by earning a reasonable return on capital and such other matters as the Commission may consider appropriate. The Commission shall protect the interests of consumers by ensuring that service providers supply to the public service that is safe, adequate, efficient, and reasonable. Every rate made by the Commission at section 10 shall be fair and reasonable and shall take into account certain elements such as the return on rate-based standards of service, rate of inflation in the economy, increases in productivity by the service provider, and ensuring that consumers are provided with universal access to the utility services supplied. We submit that the applicant has, via its written and oral evidence, which has largely been unchallenged, discharged its burden and standard of proof. It is undisputedly evident that from the written and oral evidence that a rate adjustment is necessary. It is also evident that the rate which the applicant has sought will not result in over-earning. It is of note that one of the major investments which impacted the need for the present rate adjustment application has been the Clean Energy Bridge, from which the customers of the applicant have already started to enjoy the financial benefits in the form of reduced bills, which will continue notwithstanding any rate adjustment granted by this commission. We note that many interveners have taken issue with the timing of the building of the Clean Energy Bridge. Some argue that it should have been built in 2012 and criticize the applicant for not doing so, arguing that the building of a similar plant was one of the promises of the applicant in the 2009 application. They inaccurately assert that the rate granted in 2010 was based on that promise. Further, interveners argue that if the Clean Energy Bridge or a similar plant was built in 2012, it would have resulted in fuel saving for customers. Other interveners criticize the building since it's a fossil fuel plant on the ground that it does not align with government's 100% renewable energy goal. Some interveners question the 25-year life of the Clean Energy Bridge, with some interveners questioning why it is set until 2046, which is after the 2030 renewable energy target by the government of Barbados. While others stridently argue that the Clean Energy Bridge should have an even longer life than the 25 years. The inconsistencies and incoherence in the various intervener positions on this issue betrayed a narrow and incomplete assessments on this issue by many. Such narrow assessment has regrettably been static, ignoring significant facts. The fact that under the applicable legislation, rates are not set based on statements of intention of capital expansion. The fact that the multitude of changed economic, environmental, and governmental policy factors which occurred post-2009. The fact that the 2010 decision does not state that the rate was granted on the basis of any promise to build plant in 2012. The fact that there have been many other investments by the applicant which were not included in forecasts and which have benefited customers and are in alignment with the government's 2030 vision. And finally, the legal considerations of prudence and business judgment that must be exercised when making commercial decisions in a company law context and without the benefit of hindsight. During the course of this closing statement, we will address these and other matters which have been raised by the Commission and interveners. Interveners have taken issue with the payment of dividends, and some suggest that if dividends were not paid, it would be beneficial to cash flow, and thus there will be no need for a rate adjustment. The fallacy of this argument will be explored herein. Interveners and the Commission have queried the appropriateness of 2020 as a test year, and some have characterized the test year as abnormal, solely on the basis of reduced sales. The incompleteness of this assessment has been addressed in the oral evidence and will also be addressed herein. Further, the inconsistency of any belated attempt to change the test year from a historical test, which is closest in time to the date of filing, will also be addressed herein, as any such approach is at variance with established practice. There has been no evidence put before this commission as to an alternative form of test year with the requisite support and assessment of the effect of the use of an alternative on the revenue requirement and consequent rate calculations. There has been much questioning on the self-insurance fund, and the Commission has identified the self-insurance fund as one example in relation to the issue of clawback accountability. The inappropriateness of clawback, as articulated by the Commission in its correspondence, has been addressed in oral evidence and will be addressed also herein and in our written submissions. Depreciation, specifically as it relates to service life, alignment of life of buildings and equipment, and determination of use and useful has featured also. The appropriateness of the methodologies utilized by the applicant has already been approved by the Commission in the depreciation decision, and the applicant has extensively addressed it in oral testimony by its Director of Finance and an expert witness. However, in the interest of clarity and for the avoidance of doubt, we will also discuss this matter herein. The matters on which the applicant has been probed during this hearing and that the issues which have been raised, we submit, do not undermine the applicant's proof of his case. None of them demonstrate that the applicant is not entitled to a fair and reasonable rate. None of them demonstrate that the rate base and rate of return are inappropriate, or to grant the rate adjustments sought by the applicant would result in over-earning or any reward in circumstance of imprudence. So the first of those issues, dividends. As already stated, the interveners in this matter have for the most part focused on certain themes. I have long heard that repetition is not argument, but that is not a lesson followed by some in this hearing. One such theme relates to the payment of dividends by the applicant to its shareholder, and the implied argument that if dividends were not paid, the applicant would not need a rate adjustment. This commission would well recognize that this argument cannot be entertained because to do so would immediately bring the commission in conflict with its statutory mandate to ensure, and I quote, an efficient service provider be able to finance its functions by earning a reasonable return on capital. Dividends are the mechanism through which the service provider obtains its reasonable return on capital. So what is the evidence? The applicant is presently earning 3.5 cents on the dollar, specifically a rate of return of 3.31% in circumstances where 10% is the approved rate of return. There's no argument to be made that this is reasonable. In fact, to their credit, no intervener has made that charge. Instead, what they do say is simply pay less dividends out of the inadequate 3.31% you are earning, and there would be no problem. For the commission to rule in the intervener's favor on this issue would require a finding of inefficiency on the applicant's part. And I go back to that guiding principle within the statute. No evidence has been placed before this commission to show any level of inefficiency in the applicant's operations. The evidence shows to the contrary, one of the most efficient and reliable operations in the region, with load losses comparable to the best in the world, growth of rate base in a time of flat to negative sales, and a world leader in level of renewable energy penetration on the grid. Where is the inefficiency to base any denial of a reasonable rate of return? Interveners question the existence of a formal dividend policy in a context where the managing director of the applicant has clearly laid out the 3 criteria that guides the applicant's board in its determination of a dividend payment: the financial capability to make the payment, the prevailing economic circumstances, and the approved debt equity ratio. The evidence shows the application of these criteria. In 2020, prevailing economic circumstances trumped the other criteria and no dividends were paid. The next year, a conservative $25 million was paid in the context where blind pursuit of the debt equity ratio would have required a payment in excess of $70 million. Finally, these complaints are made in a situation where the applicant's retained earnings are over $330 million. The commission is not entitled to deny a request for a reasonable rate of return simply on the basis that the applicant could survive if it paid less dividends. With no evidence of inefficient operations and clear evidence of inadequate rate of return on capital investments, the intervener theme of excessive dividend payments is a red herring meant to excite the listening public, a public that has not had the advantage the commission has had to hear and assess all the evidence, and more importantly, assess that evidence in the context of the commission's statutory obligations. Test year. The applicant has used a historical test year of 2020 in the submission of its application. This test year is based on the closest preceding 12 months for which audited financial statements were available prior to the submission of the application in 2021. As has also been set out in the applicant's evidence, adjustments were made for the then prevailing circumstances. However, notwithstanding those adjustments and notwithstanding that the established precedent in this jurisdiction as to the manner in choosing a test year in these proceedings, there has been questioning and challenge to the test year of 2020. Some have classified 2020 as an abnormal year. The only alleged abnormality identified was a reduction in sales. It has been suggested that this single factor makes 2020 an inappropriate test year. However, this single factor does not determine the financials for 2020 or for any other year. What seemingly has been ignored is, one, the clear evidence that there's been a history of decline in sales during the period since the last rate hearing, the undisputed fact that world and local economic positions have not returned to 2019 levels, and that they are unlikely to so return in the near future in light of the ongoing pandemic, the war in Ukraine, the continued supply chain disruptions and delays. While some have no problem readily accepting and embracing the challenges that existed in the economic environment in 2020, there's less willingness to accept the clear and undisputable economic challenges which still exist and have been identified locally and the world over by various agencies, including the International Monetary Fund, the World Bank, and the Central Bank of Barbados. They ignore the high inflation, which has been characterized in some jurisdictions as a cost of living crisis. The fact that the applicants' expenses have not declined, notwithstanding sales numbers. The need for adequate revenue in order to facilitate the applicant's ability to provide safe and reliable service via maintenance and investments in plant and equipment to service customers. The fact that the Light and Power has provided sales projections for 2021 to 2025, and that the actual performance for the company for 2021 and thus far for 2022 have been consistent and generally support these projections made by the company. Dr. Adrian Carter was at pains to point out the fact that the projections were performing well above the considered industry standard. The fact that no party has been able to demonstrate that use of 2020 test year would result in an over-earning is significant. The applicant maintains its choice of test year is consistent with established precedent, including the 2010 decision, which touted the appropriateness of a historical test year in the context of challenging world economic conditions, which were prevailing at that time. And that is a reason why that is a strong precedent for this commission to follow. The applicant's choice of test year is also fair and reasonable in the circumstances, as the requisite adjustments have been made for known and measurable changes. Further, it must be highlighted that the financial information relied on by the Light and Power for the test year is balanced, taking into account all relevant financial factors, unlike the narrow and skewed position taken by some in this hearing. The applicant's test year is not limited to sales, and as such, reliance on the same creates less risk to customers than the alternative mismatch approach, which will only cherry pick specific factors of convenience without reference to the whole picture. We submit that such a narrow approach is dangerous, as it would likely lead to unnecessary inaccuracies in revenue requirement. Further, we caution if sales revenue is not to be arbitrarily increased, fairness and reasonableness will require an increase in expenses, and such factors are highly likely to have an upward impact on rates. The matter of depreciation. It drew a lot of attention, and specifically for the purposes of this hearing, it relates to the generation assets of the applicant. What are the facts as presented in the evidence? The methodology and manner of assessment of depreciation utilized by the applicant was approved by this commission in its ruling of 25th March 2022. The manner by which the service lives, and by extension the depreciation lives, are determined is an industry standard that is provable and substantiated at the point of determination of the depreciation rates. What are the attacks? Intervenor Wendt and his team allege buildings should have a different life to the generation equipment which it houses. No evidence is presented for this contention, and the clear evidence of the applicant is that such buildings, being purpose-built, have no useful life outside of the generation equipment within them. The evidence of the applicant's asset management team is clear as to the recent history of the applicant demolishing such buildings at the end of service life of the generation equipment. In this respect, the applicant's depreciation policy is supported by industry standards and actual real-life experience. Complaint is made of the service lives applied by the applicant on the basis that future use may extend the life of the plant. The commission is asked to set depreciation rates on the possible use of the plant that may or may not occur at some future date. Such a basis is not supported by practice or common sense. It is of note that the applicant's expert witness on the issue of depreciation was not shown in any questioning to be undermined as to his clearly articulated position. Interveners sought to question the investment in S1 and S2 in an effort to undermine the applicant's ability to recover the reasonable depreciation expenses over the 3 to 4 year period until end of life. The asset management team articulated a clear and valid basis for making an investment that was fully recovered simply by the fuel cost savings of the first year. And I repeat that. The total investment was fully recovered by year one, simply on fuel cost savings. The decision to use S2 as spares was vindicated by the value of the critical spares, which immediately became available to maintain S1's operation during a period where COVID impacted supply lines. If the investment was prudent, and there's no evidence to the contrary, there's no basis to deny the applicant the right to recover it through the applied for depreciation rates. The chair has today indicated the manner in which the evidence of Mr. Smith will be dealt with, and we will certainly address that specifically in a filed memorandum. But suffice it to say now, in terms of cash working capital, applying the 45-day rule methodology, which is a commonly applied guideline across regulated electricity utility industry and which was accepted by the Commission in the 2010 decision, the applicant has included cash working capital in the rate base. The company's cash working capital determination reflects known and measurable changes to the 2020 test year O&M expenses. This tried and true methodology, confirmed by precedent in this jurisdiction, has been challenged with a bald statement without support that it is outdated. The facts are that this commission as regulator has never indicated a desire that there be a paradigm shift in the manner in which working capital is to be assessed for the purposes of rate review applications. Section 60 of the regulations does not require any specific methodology, and in such a case, the applicant was entitled to rely on precedent until such precedent is changed by a decision or an appropriate directive. In any event, the clear testimony is that no lead-lag study has been completed on the applicant's operations. And I do suggest it would be dangerous to seek to assume the results of such a study and make any determination on such assumptions. Much time was spent by interveners questioning the decision of the applicant not to retire its steam generation as contemplated during the 2009 rate hearing. I consider this prolonged inquiry extremely ineffective, as the issue was substantiated by the clear testimony of the applicant's managing director as to myriad reasons informing the decision, the most meaningful being the 60 megawatts of energy supply that had been approved and signed off by the government leading up to 2014. The advancement of these projects made the proposed investment in new fossil fuel plant questionable at best. This decision must also be considered in the context of government's stated renewable energy vision and program. All of this clear justification within the evidence presented calls into question the efforts of interveners on this matter. However, what confirms this recurring theme as ineffective inquiry is the clearly articulated decision of this commission in the depreciation hearing related to these proceedings, where the commission states, the commission acknowledges the concerns of the intervener and the applicant's rationale for their decision. The commission was made aware of the government's intention to install the waste-to-energy and biomass plants. Additionally, policy changes by the government in the form of the development of the BNEP 2019 to 2030 by the Ministry of Energy was part of the considerations of the Barbados Light and Power Company in its decision-making. Given the transition that the electricity market has been seeing over the period 2010 to present, a decision to retire steam units and replace them by other fossil fuel plants could potentially result in the creation of stranded assets. That is, assets that are still used and useful, but that need to be retired earlier than at the end of their useful life. In that the assets would have been determined to be prudently incurred, the recovery of those costs will still need to be borne by the Barbados consumer, and therefore will result in increased costs to the consumer. For this reason, the Commission therefore recognized the conclusion by the applicant to defer its decision to remove aged infrastructure from generation as a reasonable one. The logic of that section that I have just referenced from the decision in the depreciation hearing is solid and is totally supported by the evidence that was available. For the Commission to even consider departing from its ruling of 6 months ago in a situation where no new evidence has been placed before it, and where the issue was not even formally listed on the issues list as set at the procedural conference, would be to set a dangerous precedent. The salient fact informing the applicant's decision on this matter is that on a balance of probabilities, this reversal of an investment proposal resulted in greater cost savings to customers who otherwise would have been saddled by a potentially stranded asset, as the Commission so clearly expressed. To press ahead with an investment without reference to the then prevailing environment and the lack of relevant governmental support for the construction of a fossil fuel plant would have been folly. While hindsight is 20/20 and the utility, like other business, cannot be reasonably and lawfully be judged on hindsight, in the present circumstances, the relevant legally accepted principles relating to business judgment and prudence are in alignment with hindsight. Therefore, there is no legal basis or otherwise to deny the applicant its requested rate adjustment because of the non-retirement of the steam engine. The self-insurance fund has been a hot button issue, to say the least, in this matter, with the Commission questioning the applicant on actuarial reviews, questioning whether the generation ought to be covered. Some asserting that the monies in the self-insurance fund is all customer money since it has come from the base rate. There has also been a suggestion that if the T&D assets were commercially insured, such coverage would have been treated as an expense, and as such, no money would have been available for a payment of a dividend to the shareholder of the applicant. While some interveners have adopted the stance to the classification of all monies being customer monies, other arguments have also been made. Some of these arguments conflict, and none provide a solid evidentiary or legal basis for any attempt to retroactively claw back or order a refund to customers. The arguments can generally be summarized as follows. The self-insurance fund should remain overcapitalized, as such will provide protection in the event of catastrophe, because we are living in an environment of climate change and active hurricane seasons. The right sizing of the self-insurance fund was appropriate. However, when the money was transferred to the applicant, it should remain in the applicant fund operations instead of being paid out as a dividend. More assets should be covered by the self-insurance fund instead of taking out commercial insurance for generation and general assets. Since the Light and Power earns income through rates, the customers are entitled to all monies and net profits that would otherwise have been classified as return earnings cannot be treated as shareholder money. And finally, there should be no return of monies from the self-insurance fund to a shareholder as a dividend, because Emera was not a shareholder of the applicant at the time the self-insurance fund was created. So let's clarify and correct many of these statements and assertions. First, it is patently clear that the self-insurance fund has never been regulated by or subject to the dictates of the Fair Trading Commission. As a tribunal created by statute, the FTC's power and jurisdiction is limited to that set out in the Fair Trading Commission Act and under the legislation which it administers. For the purposes of the present matter, the relevant legislation is the Utilities Regulation Act. Neither the FTC Act nor the URA require that the self-insurance fund be actuarially assessed, limit the time or circumstances in which deductions can be made from the self-insurance fund, or require that specific assets be covered by the self-insurance fund. Instead, the self-insurance fund is regulated and subject to the Insurance Act of Barbados, and the relevant regulator is the Financial Services Commission. A review of the Insurance Act reveals there's no requirement thereunder for actuarial assessments to be done in relation to the self-insurance fund, as the self-insurance fund does not fall within the limited categories of insurance for which the Insurance Act requires actuarial reviews. Contrary to various assertions, the withdrawal from the self-insurance fund was at no time an improper or illegal act. The regulations expressly permit, at Section 8.2, utilization of the self-insurance fund for purposes other than replacing or reinstating the self-insured assets which are damaged by catastrophe and reinstating the financial loss following such damage. The only caveat or restriction on other utilization of funds from the self-insurance fund is that monies withdrawn shall be subject to corporation tax. The undisputed evidence is that the funds withdrawn were subject to tax of approximately $15 million, and the letter from the Central Bank of Barbados has been exhibited to the affidavit evidence of Mr. Roger Blackman and referred to by Mr. Blackman in his oral evidence. It must be highlighted that, one, the regulations do not require that all assets or that generation assets be solely covered by the fund. Instead, as is evident from a review of regulations, that there is no, quote, shall, quote, must, or other mandatory language in either Regulation 3, which deals with the establishment or the fund, of Part B of the schedule, which deals with generation, plant equipment, buildings, and other contents of the buildings, that imposes an obligation on the applicant to cover generation, plant, and equipment under the fund. As is clear from the oral evidence presented in this hearing and a review of the various amendments to the regulations, the self-insurance fund was established long before the 2005 amendment. No amendments to the regulations impose any obligation to create another self-insurance fund or to reconstitute the self-insurance fund for the purposes of covering generation, plant, equipment, buildings, and other contents of the buildings. The regulations do not prohibit the applicant from utilizing third-party insurance coverage for generation or other assets. However, the regulations at 5B do set a maximum monetary limit of 10% of the total assets of the company, where the replacement cost is not easily determined, thus making it impossible for the applicant to adequately cover all relevant risks it faced by sole reliance on the self-insurance fund. So let's debunk various positions taken relative to the fund from a commercial perspective. Number one, the fund is cheaper than third-party insurance, so it should be preferred. In addition to the practical effect of the maximum limit set by the regulations on the ability of the applicant to ensure adequate cover by sole reliance on the fund, the undisputed oral testimony of the Director of Finance also highlighted the commercial and practical benefits of having third-party insurance. We note that some have argued for the use of self-insurance fund instead of utilizing commercial third-party insurance because of the cost of third-party insurance. Under cross-examination, the Director of Finance would have explained why a siloed approach is not appropriate. That is because third-party commercial insurance is far more attractive generally than self-insurance, as the risk of being easily exhausted is lower, and the extent of coverage that can be secured by a premium, which is a fraction of the risk, can provide greater benefits to the customers, as opposed to sole reliance on a limited pool of funds that will take significantly longer to be replenished in the event that there's a need to respond to a catastrophe. The next matter to be debunked. The income of the applicant comes from rates, so that means all monies are customer monies, and therefore no dividend could be paid from the withdrawal from the self-insurance fund. As articulated in oral evidence, ratepayers pay for a service. Once they receive the service, they no longer have proprietary interest or ownership of the monies paid. To take a position that customers retain ownership of the funds after having paid for the service mind-bogglingly ignores fundamental principles relating to ownership, consideration, and transfer of value. If customers can receive the service and retain ownership of the monies used to pay for the service, then the business operations and economic systems will quickly fail as unsustainable. Ours is a capitalist system in which we must operate and exist. Businesses seek to make a profit. Indeed, the very URA which the Fair Trading Commission is tasked with administering refers to returns on capital and return on rate base at sections 3 and 10. That reference of return is synonymous with profit, and such return, if earned, can be utilized by the service provider, not the customer, as the legislation does not provide or otherwise contemplate that the customer retains ownership interest in the return earned. Base company law principles explain the role, rights, privileges, and entitlements of shareholders. One of the undisputed benefits which a shareholder enjoys is entitlement to dividends from the profits of the company which it owns. Therefore, the applicant strongly disputes and rejects the argument that because it earned a profit from the rates paid in respect of the services which it reasonably and reliably provided, that the shareholder of the company is not entitled in a dividend from such payments. There was also the idea that the right sizing of the self-insurance fund was appropriate. However, when the monies was transferred to the applicant, it should have remained in the applicant fund operations instead of being paid out as a dividend. This argument is again a skewed and siloed point of view, as it ignores that if earnings are retained, this stymies the ability of the company to move closer to the approved notional capital structure. As has been extensively explained in the evidence, maintaining a high equity element in the capital structure does not benefit the customers. Therefore, retention of earning does not irrevocably evaporate shareholder entitlement, and at some point it will be necessary for the company to address the entitlement. Failure to do so unnecessarily exposes the company to the risk of not being able to attract capital. The knock-on effect of this on customers is that safe and reliable service is at risk of compromise if the company is unable to make the requisite investments to maintain and acquire necessary plant and equipment. We also heard that if the T&D assets were commercially insured, such coverage would have been treated as an expense, and as such, no money would have been available for payment of a dividend to the shareholder of the applicant. There's a danger with this argument, and it is that the utility in such a scenario would be chronically and significantly under earning. The effects of such would not have been limited to non-payment of dividends. Instead, if there's insufficient money available, that will mean that other necessary investments for the benefit of customers are also at risk, and the very viability of the utility at risk. We therefore hope that the Commission does not consider that exhausting earnings to pay expenses is an appropriate state of affairs. If that is the disposition, we will remind all involved that the very statute on which these proceedings is based recognizes and mandates reasonable returns. There is the issue of the reduction in income tax. The applicant has been tested on its treatment of the benefits accruing from the change in corporation taxes in 2018. The Commission would have referenced correspondence where it indicated that the funds consequent upon the change should be held in a regulatory account and taken into account at the next rate hearing through an adjustment to the revenue requirement. The evidence of Mr. Blackman gave further context where he highlighted that subsequent to this correspondence, the Commission and the applicant agreed to instead recognize the full amount of the remeasurement gain of deferred tax liability as a current year income for 2018 and reflect such in regulatory reporting. The logic of this position was supported by the fact that there were no prior rules or requirements detailing setup and management of regulatory accounts. More importantly, as they're indicated by the Director of Finance in his testimony, this situation has arisen twice before, in 2004 and 2006. And on both occasions, it was dealt with in the manner that the applicant applied on this occasion. Both Mr. Jennings and Mr. Blackman indicated that the overarching concern for the Commission should be any element of over-earning over and above the Commission's approved rate of return. To the extent that, save for 1.75% over the approved rate in 2018, there has been, on the contrary, significant under-earning post the tax change. The consumers have not been disadvantaged in any way by the treatment applied to this tax change. And this question of over-earning brings me to a major concern I have in the context of some of these proceedings. There's a reoccurring theme in a number of the matters raised by cross-examination of the applicant's witness. That is a singular focus on supposed gains received by the applicant in any of the areas of its operations, without a commensurate assessment of the many areas of unanticipated increased expenses or diminished revenues. The Commission has to be balanced in its assessment, and where the clear evidence and testimony is that there was both unanticipated gains and unanticipated losses, the Commission must either do a detailed assessment of both sides of the ledger to determine where the true balance lies, or rely on the fact that if there was a true imbalance to either utility or consumer, it would be reflected in the observed rate of return. No substantive evidence has been led of inefficient or wasteful operations by the applicant. Therefore, a prevailing rate of return of 3.31% must indicate that if any party is being disadvantaged by these unanticipated swings, it is the applicant. And this matter brings me to the listed issue of accountability clawback mechanism. In the applicant's written submissions, it will detail the significant legal authority which dictates that this issue, as detailed by the Commission in its explanatory communication, cannot legally be implemented. However, I wish to speak now to the evidence laid before the Commission and the reason why the manner in which it is raised does not reflect equitable balance. The clear testimony of Dr. Hanser is that any retroactive review of non-implemented requirements that were set out or approved in a past rate case as a basis for a decision now to be made offends accepted rate-making policy. He simply stated it. Rate-making is a forward-looking process, and to use past requirements unknown at the time of non-occurrence as a basis for future rate setting is unfair and inequitable. The testimony is that this principle is almost universally accepted in jurisdictions which follow our rate-making principles. This testimony has not been challenged, and it is supported by both law and base principles of fairness. Even if these hurdles did not exist, the comments made earlier as to looking at both sides of the ledger would apply. What of those requirements in the last rate case which cost the applicant more than was indicated in the revenue requirement? What of those costs that were never anticipated at all? What is the message sent to the applicant who sought to manage its expenses, expend effort and money in increasing efficiencies so it would not need to look back to its regulator seeking a rate review every time an unanticipated expenses occurred? It may well very be that no good deed goes unpunished. An applicant in this position would be better served not to make it the best management decisions, but depend on rate review requests for unanticipated bumps in the road. The rate design. The applicant has developed rates which are guided by an embedded cost of service study that was led by Dr. Philip Hanser. The clear testimony of Dr. Adrian Carter is that the BLPC's rate design and revenue allocation objectives are efficiency, fairness, and revenue adequacy. BLPC has also sought to ensure rate stability. Thus, BLPC has not strictly designed rates based on the results of the study. Instead, in an effort to promote stability and limit substantial rate shock, it's taken into consideration the bill impacts. So when Dr. Carter highlights that the estimated range for increases is 5 to 20% depending on tariff, when he highlights that in many cases, the savings the consumer will incur a net decrease, the rate design is shown to be progressive and consumer-centric. This cannot be denied, where 41,275 consumers will see increases capped at $6. It is a rate design that speaks to the applicant's commitment to the sustainable transition towards the nation's renewable energy generation target. Therefore, it reduces the over-reliance on volumetric charges. The evidence reveals a rate design that's thoughtful, balanced, offers protection to the most vulnerable, and aligns with the government of Barbados policy. In conclusion, Chair, in my opening remarks to these proceedings, I made a statement that bears repeating now that the Commission has had the benefit of in-person testimony, and more importantly, the testing of that testimony by the commissioners and interveners. It was that the applicant and its management do not contend that they have been perfect in their decision-making over the 10+ years. They did not have the benefit of hindsight, which seeks to inform many of the criticisms they receive. What they can attest to is making the best decision within the context of the available information of the time. They can attest to running an efficient and stable utility which ranks with the best in the region and on some measures, the world. They can attest to being a true partner in government as it relates to the BNEP. After 15 days of hearing, no part of this statement has shown to be untrue. What the 15 days have proven is that despite the commendable performance, despite managing its affairs in a manner to increase efficiencies and contain expenses, despite investing in plant and improvements to the tune of growing its rate base by over $250 million in the face of flat to negative sales, it faces criticisms that are sometimes uninformed or blatantly prejudiced. Answering those criticisms has been the focus of this statement, but I would be remiss if I did not also indicate that I believe the value of this process has been in facilitating a testing and challenge of the applicant's requests. This is a fair process, and the Commission and the interveners are critical parties to that process. The applicant has proven the quality of its stewardship and the justification for the requested review through that very process, and is grateful for the opportunity, and therefore thanks this Commission and the interveners for their contributions. It is in these circumstances that I seek the Commission's confirmation of the orders sought within this application. Thank you, Chair.
Thank you, Mr. Allen. I now call on Ms. Dean, Public Counsel acting.
Good morning, everybody. I just listened to my learned friend refer to interveners as sometimes incoherent and uninformed and busily excitable, and basically not having an understanding of what exactly is going on in the hearing. I, however, beg to differ. I believe this is somewhat of a smokescreen because in actuality, the burden of proof rests with BLPC, with the applicant, and not with the interveners. The person who files the application must be the one to prove that they must have the burden of proof. My closing today will not be that long. I may not need all the minutes, and they could probably be given to my other interveners, because I will seek to put that in my actual written statement. But I wish to reiterate my points identified in my opening statement. I spoke to the affordability for consumers, the accountability for the applicant's action, and their need that they must operate in a prudent manner. And finally, they must provide cogent evidence to prove beyond a reasonable doubt that they actually require an increase. This increase cannot just be considered as an automatic rite of passage and as a matter of rote, nor can it be considered that the tribunal merely is expected to rubber stamp an application for BLPC for their rate increase. In accordance with Section 14 of the Utilities Regulation Act, there's a need to show that the rate is fair and reasonable. I noticed as well that my learned friend bandied about the words fair and reasonable, but in his bandying about the words fair and reasonable, he seemed to only consider fair and reasonable when it relates to the BLPC application, in that he spoke about the requirements of the FTC to ensure that the person can make a profit, to ensure certain fundamentals for BLPC. But what he constantly left out was the fact that there's a need to protect the consumer. That's me, that's a consumer like me and the average public. There's a need to ensure that the Barbadian public can afford this potential increase. In the hearing, to the discerning eye, the evidence has shown that there has been some, I'm referring to it as accounting gymnastics and manipulation of the system to exaggerate pretend, if you want to call it a pretended need. Furthermore, the applicant's lack of prudence, not just in the traditional sense of the word prudence, but also in the legal sense of prudence. That is, in paying out exorbitant dividends under the pretext of increasing their equity ratio, must force them, you as the FTC, and making a decision, must force BLPC to be accountable for their actions, to be accountable for their lack of prudence. To me, it is not simply an easy task to just make consumers accept responsibility for BLPC's lack of prudence. In this current setting, with the hardship from COVID, high job loss, high cost of living, it is unconscionable, irresponsible, and downright reprehensible to consider asking for a rate increase at this particular time. Timing is completely off. Mr. Chairman and Commissioners, the applicant filed its application in 2021 using their test year of 2020. The year 2020 was an unprecedented year. We had COVID, which drastically reduced earnings and caused significant hardships to persons with job loss. And we also had the issues with shipping and in general, 2020 would not be the year to use, because 2020 produced a situation where you had an exaggerated loss. It made everything look, to use simple words, look bad. It made things look bad for BLPC. And so it is my contention that the choice of the year 2020, although they're trying to convince us that they used it in accordance with it being the closest year to the last time they got the increase, the closest year, and usually that's the year you use. That's not true. The way we see it, that year was used because it created a very favorable position to ask for a rate increase. Sales were down, everything was down, and to use back their words, sales were flat. Their favorite words, sales were flat. To my mind, this exacerbates the deficit immensely. And this move was a way to recover losses due to a pandemic instead of a normal operational cost. It may have been better to consider using another year when things had returned back to a degree of normalcy to determine a fair and a real need for a rate increase. To my mind, this application is a strategic manipulative move to prevent the applicant from shouldering the impact of COVID, while everyone else, every other consumer, every other person in Barbados has had to burden the effects associated with the COVID pandemic. They're just seeking to pass it on to consumers, which represents an unconscionable corporate move, which the consumers need, which you as the Commission must protect the consumers from. Further to using this unconscionable corporate move to file after an unprecedented year, evidence emerged that the applicant paid a considerable sum of money in dividends to their shareholders. Emera, from monies received from the last rate increase. To make matters worse, in the 2010, there were certain obligations that the applicant had based coming out of the 2010 hearing. There were certain things they were supposed to do, one being retire the steam plant, and they did not fulfill their obligations. So my concern, therefore, is they're given a raise now in 2022 for them to once again not fulfill their obligations given to them from the FTC. And then they come back again another 5 years, another 10, to once again still not do what they were required to do. So on the surface, it appears that there is another need now to raise funds to pay another large sum of money to their shareholders. And it's also noted that clearly, even if the FTC gives orders, they're not followed, so there is nothing to stop them from doing this again. To my mind, their return for another increase to address some of the claims provided in the last hearing, they're using the excuses of Cahill, COVID, licenses, just to justify why they need a rate increase. As consumers in society and many members of the Barbados Association of Retired Persons, persons are currently struggling, unable to pay for the electricity as is. And though there's been an emphasis to try to say they've always kept the rates affordable, the reality of it is persons are struggling to keep lights on for themselves, their children, and their grandchildren. A rate increase leads to a higher cost of living as it affects many other amenities. You need electricity to pump the water tanks. You need electricity in the stores. And if the electricity is increased, every other thing will increase. And as we know, the business persons will pass any such increase on to the average consumer. And I reiterate again, the rate increase at this time cannot be burdened by the ratepayers. We already have a big burden, a strong burden. We pay taxes, we pay other things, and this, at this time, this rate increase is unconscionable. In my opinion, I go even further. When I assess the witnesses that were on the stand for BLPC, what came across clearly was that there was this, to me, they were not necessarily always forthcoming, because there was this constant passing the buck. Oh, I don't know about that yet. Your signature is at the end of a document, but you're still saying, I don't know about that. Somebody else can answer that. Yet when you sent it to the somebody else that could answer the question, that somebody else either couldn't answer, didn't answer, or did not answer satisfactorily. So to my mind, I will continue to insist that BLPC has not discharged their burden of proof. They have bandied about the word fair and reasonable, but only when it suits them. It has not necessarily been fair and reasonable in respect to the interveners. But as I continue in my closing, I wish to say that it is clear that BLPC and the BLPC, the applicant, has not proven the necessity for a rate increase. And furthermore, it almost seems as if it was expected to be a rite of passage. It was supposed to be a simple matter of you have a hearing and then it's afforded. So, in conclusion, I wish to say that the Commission needs to think long and hard, assess the evidence presented, or should I say, the lack of evidence presented by BLPC, to show and to prove that there is a necessary requirement for a rate of increase at this time. I also wish to add that in coming to their decision, it is necessary to ensure that all parties are given a fair assessment. In respect, I am referring in respect to Mr. Smith's affidavit. In light of the fact that there were certain issues which the Public Counsel faced and was therefore unable to set a firm date when her witness would have been able to give testimony, all these factors should be considered when making the decision of the weight of which you're going to utilize the affidavit of Mr. Smith. I therefore conclude that the BLPC has not proven its case, and in fact, some of their witnesses have proven there really is no need at this time for a rate increase. And therefore, I wish the Commission to ensure that they assess the evidence carefully and scrutinize the lack of witnesses being forthcoming and the fact that their case has not been proven. Thank you. And sir, I also think if there's some extra time, if you're so minded, you could consider giving this time to the other interveners. Thank you.
Thank you, Public Counsel. I now call on intervener Mr. Worm.
Good morning, sir. Good morning, commissioners. Good morning, staff of the FTC, and your support. And morning to all the interveners and all of those present. I'd like to start with a phrase, what an achievement. We have come through 14 long days up to today, and as some may say, through thick and thin, but we have made it. As I said in my opening statement, BREA was here to contribute in whatever way we could to help the Commission get information from as many perspectives as possible so that they can make the best decision in the interest of all Barbadians. Not only for today, but way into the future, and I hope this has been achieved. Through this process, interveners have challenged Light and Power about the test year and what goes into it, about depreciation issues, and in some cases over and over again, about the rate of return they have proposed and its appropriateness. They have been challenged about the revenue requirements and about their self-insurance fund and the significant adjustment that was made to it in 2016. They have been challenged about their dividend policy and the large dividends that they have paid out in recent times. They have been challenged about the investments they have made since the last rate case or lack thereof. And they were also challenged about their quality of service and their ability to respond to the changes that lie ahead in the renewable energy environment. They have been challenged about the sales forecast and its appropriateness of it, as well as their financial forecasts. And they have been challenged about their rate design and the impacts that this has on different groups of customers. And they have been challenged on several other issues, and they have responded. However, this was not only an opportunity to challenge, but it was also an opportunity for persons to become educated from different perspectives on the various issues. Not only the Commission and the interveners, but the several Barbadians who took the time to attend these sessions either in person or online via Facebook, and who through their participation would recognize that this is not a simple exercise about whether or not Light and Power should be given an increase, but more importantly, getting the decision right for the future of our country. In the electricity world, because the nature of the investments that are being made are long-lasting, any decision made today will have implications for us as a country for many years to come. Now that the hearing is almost over, eyes will be turned to the decision of the Commission. Many Barbadians may still be hoping that their decision will result in no increase in rates. However, what we at BREA are hoping for is that with all of the information that the Commission and their advisors have been able to obtain through this process, the Commission will come up with a decision that is fair and reasonable, and that it will serve Barbados' needs well into the future. Our regulatory process has served us well in the past, and we at BREA have full confidence that with the appropriate adjustments as the needs of the regulatory environment change, it will continue to serve us well into the future. It has contributed to us in Barbados being fortunate to have a safe and reliable electricity supply being provided by a utility that has been continuing to invest in the future of Barbados, which has been critical to us being where we are today, despite many criticisms. Our country started on its current renewable energy journey in 2010 when the decision was made to move the Light and Power's main rate structure closer to their cost of service and to introduce the first renewable energy rider that has allowed customers to integrate their renewable energy systems into the grid for the first time. When it started, only photovoltaic systems up to a maximum of 50 kilowatts were allowed on the grid, and the sale of excess billing method was used to reimburse customers for the energy produced. This evolved soon after with an increase in the size of the PV systems up to 150 kilowatts being allowed onto the grid. At that time, the buy-all, sell-all method of billing was introduced. The capacity that's now allowed onto the grid is up to 10,000 kilowatts, which is 10 megawatts. This new method of billing, the buy-all, sell-all, has allowed for the transition to renewable energy in a smooth and coordinated way without imposing any negative cost impacts on the non-participating customers who could not afford these systems. The testimony of its success is that today, 11% of the country's energy is now being supplied by photovoltaic systems, which is indicated by Light and Power is one of the highest renewable energy penetration levels in the world, a major achievement for a country of our size. And this has been done without the undermining of the utilities revenue base, as has occurred in several other parts of the world, including Spain. However, we cannot take our success to date for granted and rest on our laurels. We have just completed the easy part of the transition to renewable energy. Up to now, substantial costs have not been incurred in the mitigation measures for this transition to take place smoothly. However, this is about to change. We have now reached a turning point. The path ahead is fraught with many challenges, and if we are going to get to 100% renewable energy successfully in the time frame that we have set, all stakeholders will have to work together to make it happen. Many important decisions have to be made on the way forward, and we need all hands on deck. While Light and Power is no longer going to be a major investor in generating systems, they're going to need to make major investments in coming months and years in their transmission and distribution systems. As a country, we are going to be relying more and more on individual system owners to provide the capacity that was previously provided by Light and Power. So we need to make sure that they do so in a way that we can rely on them, as we have been relying on Light and Power up to now. This is going to make the job of doing this more complex, but it needs to be done. As we move forward, Light and Power will need to invest in new and upgraded substations, cables, lines, transformers, and in the development of distribution automation. They will need to make substantial investments in energy storage resources, and they will require new and upgraded control systems to manage a new way of working. They will need to implement measures to mitigate some of the challenges that will result from the proliferation of intermittent renewable energy systems on the grid, and for the transition from a single-owned and centralized generating system to a multi-owner distributed generating system. We need to find a way to make this transition work seamlessly. Light and Power's role will be changing from one of generator, distributor, and seller to one of system dispatcher, distributor, and seller. And there will now be many new players in the market linking into the grid with various technologies that have varying characteristics and profiles. The Ministry of Energy will also be taking up the new role as market monitor, and this will have a steep learning and developmental curve. From the point of view of both cost and quality of service, it is going to be critical that we get this right the first time. To do this, we need studies, pilot programs that will test the proof of concept of the new systems and processes that are needed and their applicability to Barbados. And we will need to find the most effective way for funding these. As more and more Barbadians invest their hard-earned funds in renewable energy systems, there's going to be more and more reliance on the utility to maintain a high-quality supply and to be always available for these investors to integrate into the grid so they can realize the benefits of their investments. To achieve this, Light and Power will need to continually invest in transmission and distribution resources under traditional regulatory mechanisms where there is some regulatory lag will no longer be adequate. The Commission will need to approve new and innovative mechanisms like the Clean Energy Transition Rider and/or other automatic adjustment mechanisms with pre-established principles to ensure that the progress towards 100% renewable energy continues at the pace required to mitigate the continuing threat of oil fluctuations that are presently holding the world to ransom. In this application, Light and Power has proposed to improve the transparency of the fuel clause adjustment by breaking it into the fuel clause adjustment that has only direct fuel-related costs in it and the new renewable purchase power adjustment clause, which includes all purchase payments, renewable purchase payments, and other associated renewable energy costs that may be approved by the Commission. The new structure of these adjustment clauses will allow customers to see how the fuel clause costs change over time and how they are being replaced by renewable energy payments. And we think this is an excellent idea. Another major change that will be taking place in the country soon is a transition of the transportation sector from a gasoline and diesel-driven sector to an electric, hybrid, and potentially hydrogen-driven sector. In addition to the changes that will be required to the Light and Power's distribution network to accommodate the large volume of distributed renewable energy systems, there will be a need for significant upgrades to the low-voltage distribution network to facilitate electric vehicle charging and their associated energy storage capabilities that will be needed to support the grid. In their rate design, Light and Power has done an admirable job in the way they propose to mitigate the impact of the potential increase on some vulnerable groups in the residential tariff, which we think is in the interest of all Barbadians to do. During this hearing, BREA has identified that there are other vulnerable groups within the secondary voltage power and large power tariffs that will need some attention due to major bill impacts. We are pleased that Light and Power has agreed to work with these groups and to look into solutions for them. We are also pleased that they have accepted BREA's offer to provide suggestions for addressing the impacts on some of these vulnerable groups. If at the end of this exercise, the Commission decides to grant an increase, we believe that many customers will be looking to find legitimate ways to reduce their electricity costs. Light and Power has a very valuable tool through their AMI investment that could assist residential and small commercial customers with getting a better understanding of their energy consumption patterns, and for the larger commercial and industrial customers, getting a better understanding of their energy and kVA demand patterns as well. With this information, these customers can make better decisions on how they use electricity, and this could help them find ways to reduce their electricity costs that will not only be a benefit to themselves, but would be a benefit to the overall system. We are therefore pleased that, though not committing to an actual date for this, Light and Power has agreed to make this information available to customers at the earliest opportunity, hopefully by the time the Commission's decision on these rates is made. As this hearing comes to an end, we hope that it has become clear that in the future, formal hearings like this one will be playing a lesser role in the overall process, and what happens in between these formal hearings is going to become more and more important. The cost of electricity is no longer going to be solely in the domain of the Light and Power, but will depend on many other players and many other factors. We thank the Commission for the opportunity they have given to BREA to participate in this process, and thank them, the applicant, and the other interveners, and all others involved in this process for the courtesies that you have all extended to us over the past months leading up to the hearing and over these 15 days of this process. Last but not least, and I'm sure I speak with all for all of those involved in this hearing. We would like to thank our families for putting up with the long hours that we have not been available to them at times leading up to and during this hearing. We at BRAIL look forward to the outcome of the Commission's deliberations and careful analysis of all the issues, and we have full confidence in the Commission to deliver a decision that is fair and reasonable and in the best interest of our country's future. Thank you very much, sir.
Thank you, Mr. Worm. I now invite Ms. Samantha Cummins.
Good morning, Commission and Chair. Good morning, fellow interveners, and to everyone participating or just viewing into this hearing. The Barbados Light and Power Company Limited made an application to the Fair Trading Commission for a review of electricity rates, requesting inter alia that the rate base as computed by BLPC and calculated to be $825,891,134 be approved, that the proposed capital structure of debt of 35% and equity of 65% used by BLPC in the determination of its rate of return be approved, that the rate of return on the rate base of 8.79% be approved, and that the revenue requirement of $440,240,372 be approved. The existing tariffs and riders are replaced by the proposed tariffs and riders. The BLPC has represented in its application and in its testimony at this hearing that if it does not receive the increase that it seeks, that its ability to provide safe and reliable service to the ratepayers will be compromised, and the utility will not be able to attract loans at attractive rates of interest. The burden of proof. Section 14 of the URA places the burden on the applicant to prove that the rate that it seeks approval of the Commission is fair and reasonable and in accordance with the principles established by the Commission. The issues list. The Commission determined the issues to be addressed at the oral hearing, which guided the matters of the application to be addressed at the hearing. I will not list them except to say that the Commission added accountability clawback mechanism as another issue for discussion. Legislation and legal principles. The Commission is mandated under its legislation, namely the Fair Trading Commission Act, Cap 326B, Utilities Regulation Act, Cap 282, and the Utilities Regulation Amendment Act number 20 of 2020 to A, establish principles for arriving at the rates to be charged, set the maximum rates to be charged, monitor the rates to ensure compliance, and carry out periodic reviews of the rates and principles for setting rates and standards of service. The Fair Trading Commission Act and the Utilities Amendment Act define rates to include every rate, fare, toll, charge, rental, or other compensation of a service provider or renewable energy producer. B, a rule, practice, measurement, classification, or contract of a service provider or renewable energy producer relating to a rate. And C, a schedule of tariff respecting a rate. Section 10 of the Utilities Regulation Act, Cap 282 of the Laws of Barbados stipulates at paragraph A that every rate made by the Commission shall be fair and reasonable. Subparagraph B sets out the considerations that the Commission must regard when determining rates as follows. in accordance with the principles established by the Commission under this Act or set out in rules, orders, or regulations, and shall take into account 1. The rates being charged by competing service providers for supplying a similar utility service, the standards of service being offered by the service provider and by competing service providers. 3. The return on the rate base, the rate of inflation in the economy for any preceding period as may be considered. That was 4. And 5, the prospective increase in productivity by the service provider. 6, ensuring that consumers are provided with universal access to the utility services supplied by service providers. And 7, such other matters as the Commission may consider appropriate. Implicit in the regulator executing its statutory mandate in rate setting is that it has to balance the interests of the ratepayers with that of the utility. The U.S. Supreme Court landmark case of Federal Power Commission et al. Versus Hope Natural Gas Company, the Hope case, is the legal authority which set the principle that a regulated utility is entitled to a reasonable opportunity to recover their prudently incurred costs. The earlier landmark U.S. Supreme Court case of Bluefield Waterworks and Improvement Company versus Public Service Commission of West Virginia, called the Bluefield case, established the principle that a regulated utility is entitled to earn a fair and reasonable rate of return on its capital investment. Regulator apply these principles and those established by James C. Bombay et al. In the book entitled Principles of Public Utilities Rates, also referred to as the Bombay Principles, to determine rates for investor-owned utilities that balance the interests of the ratepayers with those of utility shareholders. The Bombay Principles enunciate that the attributes of a sound rate structure are as follows. Rate should have the following practical attributes: simplicity, understandability, public acceptability, and feasibility of application. 2, rate should be free from controversies as to proper interpretation. 3, rate should effectively yield total revenue requirements under the fair return standard. 4, rates should provide revenue stability from year to year. 5, rates themselves should be stable. That is, rates should experience minimal unexpected changes that are seriously adverse to existing customers. Rates should apportion the total of service fairly among different consumers. 7, rate relationships should avoid undue discrimination. 8, rates should promote efficiency, discouraging wasteful use of energy while promoting all justified types and amounts of use. Now, we go on to, has the applicant discharged its burden of proof? The Division of Energy may agree that the applicant has made a prima facie case of its need for a rate increase. However, making that prima facie case only entitles the applicant to be heard by the Commission. The applicant now has to prove to the Commission within the criteria set by Section 14 of the URA mentioned earlier that it is entitled to a rate increase. The Division of Energy submits that the applicant has not discharged its burden of proof to persuade the Commission that it should get the increased rate that it is requesting, or at a minimum at the rate of 8.79%. The Ministry intends to elaborate on this further in its written submission. Notwithstanding, the Ministry will state that, 1, when the applicant was challenged on its assertion assertion that if it did not get the increase, that it would not be able to obtain loans at attractive rates because it had a steady decline in sales over the last 10 years since the last rate increase, which resulted in its not realizing the rate of return allowed by the Commission in the 2010 decision. It could not indicate one time during the said period that it was not able to attract favorable financing. 2, the applicant's ability to make such handsome disbursements of dividends to its shareholders counteracts and dissuade from the argument that the applicant is in dire financial straits. The applicant is obliged to prove to the Commission that it was and is prudent at all times with its financial management of the company, and notwithstanding, it finds itself in a negative outlook. 3, in this hearing, when some of the applicant's witnesses were cross-examined by the Commission on the basis of their assertions, calculations, applications, and methodologies, revealed that there were some flaws that would require them to review their conclusions. 4, the applicant was evasive at times to questions placed directly to it by the interveners and the commissioners. The BNEP. In my opening statement, I would have laid the foundation for the ministry's concern of how a rate increase may adversely impact upon the success of the BNEP, known as the Barbados National Energy Policy. The Division of Energy will elaborate on this issue further in its written submission. However, I will highlight a few here. The BNEP has goals of, the BNEP has goals which include that electricity or energy, if you want to call it, is of 1, affordable, and 2, accessible by all. It will be a challenge to meet these goals if electricity is too expensive to buy. It may be remembered that the world is experiencing a recession, which unfortunately has not excluded Barbados, which is also trying to recover from the ravages of the pandemic, which in itself was and continues to be a costly affair. There are also other external factors which have seen the cost of basic food items and other commodities and services increase exponentially. It is understood that the applicant, like all of us, is not immune from these influences. However, the applicant, because of its unique position in the service industry in Barbados, that is, being the only electricity company or provider in Barbados and the owner of the national grid, still will enjoy some cocooning with respect to certain aspects of its operations that will always remain a rate base, for example, the transmission and distribution. The increase in electricity will automatically trigger an increase in goods and services in the island, which will marginalize certain classes of citizens even more, who will find it hard to invest in the renewable energy market, thus threatening the BNEP's goal of becoming carbon neutral by 2030. Persons who cannot afford to invest in renewable energy systems will still be reliant on electricity generated from fossil fuel sources, thus curtailing the subscription to the initiative by citizens. Conclusion. It has been established that the Commission has to balance the interests of the taxpayer with those of the shareholder. This is not an easy task and comes with its own complications with achieving a common ground. The Commission, in discharging its duties, has to ensure that the applicant makes a reasonable rate of return so that its investors can earn reasonable returns on their investments, while ratepayers pay no more than is just and reasonable for their use of the service. A question also has to be asked whether the applicant's analysis and determination of what its financial needs are to comply with its regulatory obligations will satisfy the bond right principles aforementioned. Were the Commission to accept the applicant's submission? For example, in designing its rate base, is the Commission satisfied that the applicant has sufficiently apportioned the total cost of service fairly among different classes of consumers? Are the rates proposed by the applicant have the attributes of simplicity, understandability, public acceptability, and feasibility of application? It is the applicant's burden to convince the Commission that the increase in the rates that it seeks is meritorious and therefore should be granted. The evidence presented at this hearing does not support the application for reasons mentioned earlier. The applicant, being evasive in some of its responses, did not assist its case in any way. To rebut the applicant's evidence in this closing will require more than the 20 minutes allotted to the Division of Energy. Therefore, the division will elaborate on its conclusions more comprehensively in its written submissions. I'm obliged.
Thank you, Ms. Cummins. I now call on the intervener team of Watson and Simpson to present their closing.
Thank you, Mr. Chairman. The intervener team of Watson and Simpson is exercising its option not to make an oral closing statement. This team will file its fulsome written arguments during the prescribed period, and you can rest assured, Mr. Chairman, that those arguments will be impossible to ignore or dismiss. Any statements that we have to make, we will make directly to the very astute customers of the Barbados Light and Power Company Limited and the clients of the Fair Trading Commission, namely the people of Barbados. Thank you, Mr. Chairman.
Thank you, Ms. Watson. Okay. I now invite Mr. Kenneth Went.
Good morning, all. Thank you, Mr. Chairman. I've heard, Mr. Chairman, that a number of my colleagues were not able to utilize their time. If I could be given more time, it would be appreciated. Mr. Chairman,
Went,
Commissioner.
Mr. Went, you know there's also, you're also able to submit written submissions, so,
Yeah.
so use the time wisely.
Right, I would, Mr. Chairman, but you
Thank
would appreciate the last 15 days, everything is behind, so
Yes,
I'm not
and-
even sure. So if I can do it now, I'd be really appreciate it.
Thank you.
Mr. Chairman, Commissioners and FTC staff, the BLPC Managing Director, Mr. Blackman, BLPC lawyers, the consultants, the expert management and staff, fellow interveners, the media personnel, ladies and gentlemen, greetings. The time is now 10:44, and I'd like to be given an hour, but if I get less, I wouldn't mind. Over the past months, our team, Dr. Harley Alfar, Mr. Adlai Stephen, Mr. Tony Gibbs, and I read numerous documents, conducted extensive research, analyzed a series of reports, submitted several interrogatories, and examined BLPC's operations in great detail and much more. Over the period, presentations to BARP, the Barbados Chamber of Commerce and Industry, the Barbados Cooperative Energy, and the wider public. We've done on television, on radio, and because we wanted Barbadians to be aware of what was going on, to get a full appreciation. We cannot calculate all the long hours involved or the costs incurred for this entire process. After submitting the letters of request for extension, we spent the last Christmas preparing and filing a 44-page letter of intervention, which expressly indicated that virtually all key aspects involved in the test year would have been examined. Apart from a few exceptions, the record will show that we made significant input on the vast majority of the key issues, and now take this opportunity to summarize our key findings, submissions, and recommendations. We trust that all letters, affidavits, exhibits, and oral and written submissions hopefully would have proven helpful to the Commission in arriving at the decision on the confidential and interim rate relief hearings, Prior to those inputs, we trust the feedback to the Commission on depreciation decision was instructive. While the above is only a capsule of the work undertaken before and during the public hearings, we hereby turn our attention to several of the key facts, submissions, and findings during the cross-examination of internal and external witnesses appearing on behalf of the applicant. Let's look at the test year, 2020. Our team still maintained that the 2020 was so abnormal that it is far from ideal to be used as a test year. Yet, bearing in mind the months that have inevitably elapsed prior to the hearing, we support its use provided that all pertinent known and measurable changes be included to reflect the future as realistically and intuitively as possible. For example, everyone accepts that revenues in 2000 were depressed due to the pandemic, lockdowns, layoffs, closures, and the hotels and retail, out of work. However, BLPC continues to resist making any relevant adjustment in the 2020 test year in relation to revenues. Operating revenue. As per the Excel sheet, and Mr. Chairman, I wouldn't want to call all of the references, so I would probably have to share my closing remarks because they take time. But in tab 3.2, Q33.2, with on the key event financial data request, received on October the 2nd, you would have seen that the revenues the basic revenue was 186.038 million. The previous 5 years, and that is 2017 to 2019, basic revenue was 191.478 million, 196.803 million, 197.068, 195.382 million, and 196.21, respectively, an average of 195.389 million. Accordingly, our team is of the view that if the revenues are flat, then a non-measured change of 9.351 million, which is the difference between the average and the 186 million in the test year, should be included in the 2020 test year. At page 706 of the application, it is noted that the revenue of 279,000 from the energy storage devices, also called battery revenue, was included as miscellaneous revenue. In line with the request to include the energy storage devices in the rate base, the company proposed to remove the revenue of 279,571 from the miscellaneous and include it in as part of the basic revenue. An appropriate adjustment of 279.571 thousand was deducted from miscellaneous revenue, but our team was expecting a corresponding known and measurable change to be added to basic revenue in the 2020 test year. This may have been an oversight. The company correctly removed the incentives as they earned in 2020 by taking a reduction of 1.412 million in known and measurable revenue adjustments in the 2010 test year. Equally, any penalties incurred in 2020, which were included in the operating expense, would have had to be removed as known and measurable changes. It was reported that the penalties in 2020 were minuscule, possibly in the region of 15,000, so that really wouldn't matter a lot. Actually, the only concern which was unclear is how incentives were achieved and whether these were earned at the expense of higher heat rates resulting from deployment of gas turbines. But we didn't have enough time to fully analyze that. Fuel charge expense and savings. The fuel charge is the biggest expenditure item which is in the test year, with $202.978 million, and is solely borne by the ratepayers. The exponential rise in the oil prices resulted in public outcry, and government responded by reducing VAT on the first 250 kilowatts of usage from 17.5% to 7.5% in order to give ratepayers some relief. The company asserts that the installation of the new clean energy bridge will save ratepayers and the country $30 million a year in fuel costs. In his testimony, Dr. Carter advised that the savings in the fuel costs were $9 million in July 2022 and $10 million in August 2022. The manner in which these savings will accrue to ratepayers is unclear. Since the FCA is a pass-through expenses, an adjustment should be made to specifically reflect the benefit to ratepayers in the test year. In order to reflect the savings which are to accrue to customers, should no other measurable change be adjusted by means of reduction in the fuel expense in the test year? If so, by how much? What would be a reasonable adjustment? Insurance, self-insurance fund, the SIF and the general insurance. According to the extract of the laws of Barbados, Cap 310, Section 8, appended to Mr. Blackman's affidavit of 6 October, the SIF was established to cover generating plant, equipment, buildings, and other contents of the buildings. This is in line with the extract from the published 2008 annual report, which states that the SIF was established primarily for the purpose of building an insurance fund to cover risks against damage and consequential loss in certain generating, transmission, and distribution systems. And that's at page 30 in the 2008 annual report. Ratepayers contributed handsomely to a SIF since the 1990s, after the insurance for the TND was either unavailable or prohibitively expensive. For example, insurance in 1998 would have been just $1.158 million. However, $4 million was added to the SIF, which meant that the total insurance for that year was $5.18 million. Remember that 2008 was a test year in the previous rate review by the applicant. So the pattern of those payments into the SIF continued over the years. By 2011, a study concluded that the amount held in the fund of approximately $128.4 million was adequate to cover regional lists. Leighton Post Holding 2012 report, page 30. The assets of the SIS accumulated to $146 million in 2015. Apart from TND, the SIF has the flexibility to cover generation as noted above, even though it was only used to cover the deductible on general insurance for a limited period. In the 2016 non-consolidated financial statements, the net book value of the TND generation plant was $310 million and $224 million for the TND was 301 and generation was 224 million. In a study conducted by Emira, it was determined that the SIF had excess in brackets and was beyond what was necessary to cover regional risk for TND. Instead of extending the scope of the SIF to include generation, which the scheme permits, the trustees of the SIF opted to return the excess to the applicant. By the end of 2016, BLPC paid excess from the SIF to the sole shareholder in the form of a dividend of almost $100 million. The net result was that the assets of the SIS of $146 million in 2015 plummeted to $50.2 million by December 31st, 2016. Meanwhile, general insurance has been increasing to the point where in 2020, the cost was $8.2 million. In the 2020 test year, ratepayers are now being asked to bear a 50% increase of $4.1 million as a known and measurable change. Recent information for the company shows that general insurance covers for property is $10.064 million, which presumably includes generation. However, our request for the specific amount pertaining to generation is still awaited. Mr. Chairman, it is understood that Emira Reinsurance Limited, ERL, is a captive insurance company incorporated on laws of Barbados and a wholly owned subsidiary of Emira, which provides insurance and reinsurance to Emira and certain affiliates to enable more cost-efficient management of risk and deductible levels across Emira. In response to Commissioner Martinez yesterday, we thought that Mr. Blackman initially said that there were 3 different types of insurance coverage, namely the SIF, the general insurance, and the ERL. However, subject to correction, Mr. Blackman later indicated that there was just the SIF and the general insurance, as the ERL no longer covers BLPC since 2020. In essence, now that the $100 million is paid in dividends, the ERL dropped the Barbados Light and Power Company. In view of the foregoing, our team submits that an appropriate adjustment in the form of a known and measurable change ought to be made to effectively remove the premium related for generation that is covered under general insurance going forward, if only for rate-making purposes. In so doing, the expense would not be a burden on ratepayers. Furthermore, Since none of the excess of the almost $100 million which the ratepayers would have injected into the SIF over the years was returned to them, then the Commission should use its mandate to disallow the non-amendable change of $4.1 million in the test year so as to avoid consumers facing double jeopardy. Clean energy bridge. As far back as 2009, BLPC indicated that its aim was to install a plant that is efficient and which is of the lowest economic cost to the country, such as medium-speed diesel units. And that was in the 2010 decision at page 24, paragraph 62. The Clean Energy Bridge was ordered on the 29th of November 2019 and commissioned on the 29th of June. The cost of the Clean Energy Bridge is $144.5 million, comprising equipment of $97.8 million and buildings of $43.6 million. The CEB was assigned a life of 25 years, both equipment and building, which was a minimum based on the ONEM specifications. However, the company's generating units, such as the low-speed diesel 10 and 13 and the low-speed 14, 15, which were to be retired in 2018, had an average service life of 33 years. And that's in the application of page 804. The low-speed diesels are scheduled to be retired in 2028, so this means that average life would be 43 years. And that's on RJ1, which is exit from Peter Hutz 2. The low-speed diesels 14 and 15 were installed in 2005, page 786 in the application, and are scheduled to be retired in 2035. So the average life is 30 years. Therefore, given the company's actual experience with steam plant having an average life of 47 years and the low-speed diesels having an average life of 37 years, the FTC should apply a life of at least 33 years to the Clean Energy Bridge instead of the minimum 25 by the years by the OEMs. The depreciation expense in the test year would then be $4.3 million, and that would be $141.5 million divided by 33 million, instead of the $5.3 million, which was the $133 million divided by 25. Like any asset, the CEB will have to be maintained, so the company correctly included $4.8 million in the 2020 test year as its annual operating and maintenance expense. If correct, the maintenance expense should be allowed. The company indicated that the improved value of the CEB property resulted in an increase of $1.2 million as a non-measurable change in the test year. In order to cover land taxes, the company must be given the revenue which will be subject to corporation taxes. When rates are set, then VAT applies. Therefore, an increase in land taxes effectively results in a tax on a tax on a tax. Accordingly, our team did write the Ministry of Finance on the 8th of August, respectively requesting a rebate since the 10% VAT relief granted by government was only for a limited period. Unless some tax concession is granted by the relevant authorities, the expense of the $1.2 million should be allowed. Low-speed diesel lubricants. The company indicated that the low-speed diesel was out of service for a considerable period during the 2010 test year. BLPC response to our interrogatory of the 30th of June, showing service hours rendered by each generating unit over the past 5 years, supports the company's contention. Therefore, no measurable change of the $1.7 million requested by the company and including the test year to cover the lubricants for the low-speed diesel 15 should be allowed, assuming it is correctly computed. The steam plant units S1 and S2. More than enough has probably been said about the steam plant, which the company first committed in 2009 to retire by 2012 and replace it with new units to save ratepayers $30 million. After the new equipment was not ordered in 2010 or in 2011, the company outlined several subsequent reasons why the system S1 and S2 were kept in service, which we rigorously disputed based on the facts. Considerable sums were spent to keep the steam plant alive for 10 years thereafter. The company ignored FTC's repeated requests to replace the old and inefficient steam plant. In the 2020 test year, ratepayers are now being asked to pay the estimated $4.5 million in depreciation expense to recover imprudent funds spent to keep the old steam plant functional, with one unit being refurbished, the S2, and kept as spares for the other one. Yet, for prolonged periods, units S1 and S2 were not available to render service, and that's in the request of August 20th, That will be question 39F. The FTC should use its mandate to disallow the $4.5 million depreciation expense for rent-making purpose. The steam plant is now scheduled to be retired next year, 2023. Therefore, the maintenance cost of $3.9 million for the steam plant incurred in 2010 this year should be removed as the system is being retired. In addition, lubricants used by the steam plant in 2020 test year, we estimate that could be about $1.25 million, but that's subject to verification. In any event, it should be removed from the revenue requirement of $46.5 million. According to the company's policy, buildings which house generating plant are demolished on retirement of such assets. Our team strongly opposes this practice and firmly believes that all buildings should have separate lives, which typically would be in the range of the 45 years currently used for buildings that do not house equipment. Yet, in line with the company's practice, the improved value of the steam plant, estimated at $1.0 million, subject to any verification, should be deducted from the taxes on income in the test year 2020 to reflect the demolition of the building. The company could then reapply to the Commission of Land Tax to get the appropriate adjustment made in the land taxes. Other generating expenses. At page 733, BLPC application, the company is correctly removing the cost of the $9.6 million incurred in renting the 12 megawatt diesel generation as a non-measurable change in 2020. Similarly, the gas turbine GTO1 expenses, that $0.7 million, as well as other aggregate expenses and so on, are appropriately being removed from the 2020. And we support those provisions. When all the adjustments taken above are as non-measurable change for generation is a net reduction of $9.7 million instead of the $4.6 million in the application is expected. Depreciation. Apart from depreciation adjustments highlighted above in relation to Clean Energy Bridge and the steam plant, the company's overall computation is worrisome. The company repeatedly refers to its various depreciation studies and contended that it follows the FRS standards. While the company's choice of depreciation rates and computations for its published accounts can be what it determined to be appropriate, BLPC must adopt and apply the depreciation rates as prescribed by the FTC in its decisions. Consequently, the company has to prepare and use the same when applying for rates. I've settled the table, but I'll give you that later. It must be stressed that the annual depreciation computations for regulatory purposes must be based on the rates approved by the FTC. Only when the FTC issues new decisions should the company apply new depreciation rates. In other words, the depreciation rates which the company should be using in the current application must be those which the FTC approved in 2019. The FTC recently issued a depreciation study on a decision on the 25th of March, but expressly state that the depreciation rate approved herein will become effective concurrent with the rates to be approved on the effective date ordered in the ongoing rate review. And that's at paragraph 5 of that, page 5, paragraph 8 of that decision. In addition, with effect from January, the Commission approved the adoption of remaining life, which we also support. At page 5, yes?
I'll give you an additional 5 minutes.
Thank you. I'll have to submit this because this is the hurtful part of it. No, it's painful, Mr. Chairman. The committee does not approve the depreciation rates for generation. It did not. So the depreciation rates and expense over the period 2019 to 2021 from the non-consolidated statement show that about $7 million more in depreciation expense is there, and we would like to be able to do the calculations, but that should be removed as a non-measurable change. Mr. Chairman, I'll try to flick through this as fast, but I have to give you the detail. This is not good. Should the FTC finds favor with the depreciation recommendations, the Clean Energy Bridge, the total reduction in depreciation could be $8 million, which is $7 million on the general depreciation on the generation, plus the $1 million we have shown in the Clean Energy Bridge. The recommended disallowance of the $4.5 million depreciation expense for the steam plant would increase the total reconciliation as necessary, but it would not be a straightforward addition since we know that steam units are also generating plant. We would not be surprised if the final known and measurable change for depreciation as a reduction includes $10 million. the impending restructuring. We have spoken about this, and we've set out a lot of that, and we've written on that in our special submission that we sent to the board. We wanted to highlight some of the key aspects, but we will move on. The company's tax windfall. Before that, though, sorry. In BLPC's 2014 and 2015 restructuring, the company spent $15 million to $20 million in its regulatory account, so a savings per annum could be at least $5 million. You're not going to spend that money without a return, so that ought to be considered. The corporation tax has been fall. That we've seen that, and I'm going to have to go very quickly, I can't do it as I would like, but what we've seen is that the tax has dropped from 15% to 2.34%. It's pretty company. And the income taxes was 53.16 million and 54.1 in 2018 and 2019. That's the tax, the income before taxes. The corporate tax rate was reduced, resulting in a corporation tax that was 7.97 million in 2018, becoming 2.9 million respectively. If the rate had not changed to 15%, then the corporation tax in 2019 would have been 8.12 million. Therefore, corporation savings would have been 5.48 million. As a proxy, if the tax savings are amortized over a 5-year period, then a known and measured change of 1.03 million per year, that ratepayers can also reap some of the tax benefits. Fundraising. This was discussed, so I can't really go into it as I would like, but essentially, we do not support the company's view that it will have difficulty raising financing. The debt equity ratio, I want to spend some time on that, but because we don't support the view that having the company says it is going to have major investments, then how could it be now that when we should be born to increase the debt and bring the ratio down, we're just paying them out in dividends. The return on equity, Dr. Valentine, in relation to company risk, industry risk, and company risk, that it was heartening to see that the outlook is improving steadily. In relation to country risk, confidence is gradually returning, such that Barbados' risk profile is improving. In this regard, the risk-free premium for Barbados declined from a high of 30.87% in 2019 to a low of 6.29% in 2021, and that's the Valentine report, with an increasingly positive outlook. With the electricity sector, there are some uncertainty, but overall, the risk is relatively low. BLPC has never defaulted on any of its loans and is able to raise loans right now at 2.78. Hence, I won't go through all the analysis that we did, but I will have to share it with you. When we are finished, we believe that a basic debt of 2.78%, we firmly believe that the risk premium should be that of what the country receives from the Vogelheim discounted cash flow, and I would have liked to be able to go through this. This hurts. So in 2008, we had a situation where the return on debt was 5.25%, and the company asked for 13.5%, which would have been a spread of 8.25%. That was in the 2008 case. What was approved was a 5.25% debt and a 12.75%, given a spread of 7.5%. The company now in 2020 is requesting a spread of 9.72%, which is the 12.5% minus the 2.78. We believe, as we said before, what should be added to that 2.78 is 6.3%, which is the company risk, to bring the company's debt to the return on equity to be around 9% instead of that 12.5 that is being requested. Rate base, we can't discuss that as we would like, but we note the reduction that it has made, the jump that was made the last 4 years. I now turn to, this is hurtful.
Mr. Vane?
Yes, could I get a couple more minutes, Mr. Chairman, please?
No, Mr. Vane, you have the opportunity to, you can submit written submissions. So
Yeah.
all of the information that you have, we would expect you to prepare a formal written submission, which is due on the 28th of this month. So you still have the opportunity to put all of your points in your written submissions that we will consider when we are considering all of the evidence.
If you can, I did hear somebody in Venice ask to give that. If you could give me 3 minutes, Mr. Chairman, I would appreciate it.
Mr. Vane, are you still going to put it in your written submission?
No, because I may not have time.
No,
Everything
I'm
I do
saying,
behind.
Mr. Vane, just wait. you have 2 weeks in which to prepare a written submission. All of those good points that you have presented this morning, you could put them and any other points in your written submission, which this panel will consider.
I agree, Mr. Chairman. What I'm saying to you, I'm pleading with you now. I'm so busy, Mr. Chairman. I had to tell all of my boards to give me a break. I still have a class action suit with Cable One. I don't know if I have any time to do anything more.
No, but you
So
could
just give me
submit
3
what
minutes.
you could submit what you have, what you're reading from.
But I have to, they just roughed here. I'm trying to read it fast and I don't have time. But
No, but I'm just saying
please give me
you
3
could
minutes, Mr. Chairman.
You can submit it, Mr. Vane.
Could I get 3 minutes, Mr. Chairman?
Yeah, 3 minutes.
3 minutes.
3
Sorry,
minutes.
The revenue report.
Please note it is 3 minutes, Mr. Vane.
I appreciate it, sir. The company is seeking additional 46.4 million, and we're saying some adjustments. So the adjustment should be the revenue requirement of the 186 should have adjustment of $10 million in revenue. The ratepayers of the country should receive then the savings from the Clean Energy Bridge, which is $9.5 million. We also notice that the $100 million that was taken from the CIS was paying a dividend, 50% rise. So the adjustment in the 4.1 should be disallowed. The service life of the Clean Energy Bridge should disallow $1 million. The ratepayer should not be asked to fund the depreciation expense of $4.5 million. S1 and 2 retirement, that maintenance cost of $3.8 million should be removed. And we also would like the lubricants for the for the steam plant to remove. We also would like that the depreciation on generation, that $7 million to be removed. And we would advise that the restructuring cost should be about $5 million. So when we looked at the reduction from the 12.5% for the to the 9% should be 0.9 million, so it's a significant reduction that we're seeing. Mr. Chairman, I want to make mention of your discussion we had with Mr. Dr. Carter, because you correctly says that how could $300 existing tariff move to $1,587 and that be seen as written, but I can't go to that. So in summary, the CB ordered on the 28th of 2019 was less than 2 weeks after the island-wide outage. We have to ask if the outage has anything to do with the order being placed. Ratepayers struggling to make ends meet, so every effort must be made to find the right balance. Many reasons are still, our people are still out of work, and we've also seen that the company gave commitments in 2012 that were not honored. It cannot be that the ratepayers contribute handsomely to the SAFE only to find themselves to remove $100 million in dividend and now be asked to pay $4.5 million as a $0.5 million change. And finally, Mr. Chairman, we have noted that Tampa Electricity, which also had the same tax break from the federal government, was able to return some of the tax incentives to the ratepayers in Tampa, and we cannot understand, since Tampa is also familiar, why is it that then some couldn't accrue for it. Now, in closing, Mr. Chairman, we can go on, but there's so much more, but time does not permit us to expose everything. At this point, we would like to express our sincere gratitude for giving us the opportunity to be part of the process. Our team appreciates its extended appreciation. It's extended to the numerous persons who prayed and wished us well. Thanks to the media, the ACRA, and the persons who would have assisted us in any way. With that, we trust that the contribution would prove helpful to the FTC in achieving equity for all shareholders, ratepayers, the Light and Power Company, independent providers, and the country in general. Mr. Chairman, I thank you very much.
Thank you, Mr. Vane, and we still invite you to submit your written submission by the 28th of October.
I'll try and get the time, but it's very tight, Mr. Chairman. It's 3 o'clock nights, you wouldn't believe.
Okay, thank you. Lieutenant Colonel Brown.
Good morning, sir. It has been an honor, sir, and a privilege to represent the Coalition of Cooperatives in this important electricity rate review hearing. On behalf of my co-intervener, Mr. Halley Haynes, and myself, we wish to thank the chairman and the commissioners, the director and staff of the FTC, all of our fellow interveners for their support and encouragement which we've received during the process. We want to say a special thanks to the BLPC team, whose professionalism we feel compelled to admire, even as we challenge the flawed narrative which they have attempted to put to the Commission. At the end of the hearing, sir, the Coalition is even more concerned than we initially were about the urgent need for radical reforms in energy management in Barbados. Local national energy legislation has wisely established Barbados Light and Power Company Limited as a regulated public utility to serve the public good of Barbados. And for over 100 years, this structure served the electricity needs of Barbados well, with representations from all stakeholders. Between 2011 and 2014, however, Emera of Canada, acquired 100% shares in BLPC and proceeded to completely transform the company from a regulated electric utility into a mechanism to generate cash for its new sole shareholder. Whereas for generations previously, about 15% of net income from this company had been paid in dividends to shareholders, while 85% on average was reinvested into BLPC's operations for the benefit of Barbados. We have seen since 2011, 86% of income being extracted as dividends, leaving only 14% for reinvestment into the utility and into this country. The facts show, Mr. Chairman, that the assault has impacted on the company's operation in many critical areas, including delaying investment in critical, efficient baseload generating plant, downgrading the transmission and distribution maintenance standards, leaving hundreds of leaning and rotten poles all over Barbados, degrading the critical self-insurance fund, which was creatively put in place in 1993 to protect the company and this country in the event of catastrophic damage. And sir, these and other actions and failures to act have resulted in significant additional costs to customers since 2011. Costs like higher than needed fuel charges, reduced reliability, excessive operating costs as a result of old retired generating plant being reinstated, whose high costs have to be borne by customers, and significant reductions in maintenance, especially on the T&D infrastructure. As a regulated public utility, sir, the Barbados Light and Power Company Limited is established to be administered as a franchise through a license which, as you know, is issued by the government of Barbados. This license, the current license, expires in 2028. While Emera obviously anticipated an automatic rollover of the franchise, the Barbados government has wisely reviewed the whole process closely, particularly, sir, in light of the country's declared national objectives to radically re-engineer the local energy framework into one that is based on sustainability through the Barbados National Energy Policy. Officials of Emera have publicly challenged government stance on this question and on licensing. The result has been an impasse, which resulted in energy leadership in Barbados and a clear lack of harmony and progress with the build-out of the Barbados National Energy Policy. The BLPC's application for an increase in rate, and even more so, their request for an interim rate increase, are the latest examples of the disharmony of which I speak. Sir, the simple financial facts are impossible to misread. Barbados Light and Power Company has not had a single year of financial loss in recent memory. In recent decades, sir, not a single cent has been invested into BLPC by Emera or any other investor. At the same time, and on the other hand, since the last rate hearing in 2010, customers of BLPC have paid $6.3 billion as revenue into that company. Included in that $6.3 billion, sir, fuel charges of $3.75 billion, much of which resulted from delays in the installation of efficient equipment. Sir, the net income generated by the company in the period has been $635 million from their own records. But of that total net income of $635 million, $538 million has been extracted by Emera as dividends. Meanwhile, unexplained decisions were taken by the company to delay investments in critical base load plant, which had been promised in the 2010 hearing on condition that the rates were approved. At the same time, sir, deep cuts were made in BLP resources that had been previously dedicated to transmission and distribution maintenance to keep the infrastructure in tip-top shape for this country. For reasons that are yet to be explained, a self-insurance fund valued at about $150 million, designed to protect this country, the company, and customers in the event of an unforeseen catastrophe, have been unceremoniously withdrawn from that fund. The company's own records, sir, show a return on base rate of 3.8% in 2020, the test year. Sir, in 2020, almost every other operation on this earth suffered globally suffered very, very badly. In fact, sir, the country Barbados in which they operate saw a near 20% decline in GDP, according to the central bank. BLPC's growth of 3.8% in that environment therefore reflects an effective relative performance of something like 24% in reality. Sir, the facts are, the company's debt levels are extremely low. Indeed, it is the lowest among the group of companies which they themselves selected for comparison on page 268 of their own rate application. They have the lowest rate debt levels. In that same chart on page 294, it shows that BLPC's profitability is among the best of all the companies that they selected from that peer group to compare themselves with. The company has been unable to show any evidence of any kind of financial stress that would warrant asking customers to put in even more than that $6.3 billion that they've put into that company over the last 10 years. Officials have merely cited the need for a company profitability to improve even more, according to them, so as to be more attractive to needed investments. Investments from who, Mr. Chairman? The only people invested in this company in the last 20 years have been customers. Only customers. In the meantime, the company, contrary to assertions from their lawyer as recently as this morning, have asserted that there is no company policy on the payment of dividends. In fact, officials have conceded, in direct answer to questions from the coalition, that there is nothing to prevent any rate increase granted from being paid to shareholders as dividends as we currently stand. Sir, I would just like to draw the Commission's attention to on paragraph 185 of the 2010 rate decision, when Commissioner Knight questioned the rationale between the high dividends being paid by BLPC. Sir, this was in 2010. In that same paragraph 185, the Commission expressed the view that significant increases in dividends may not be prudent, and I quote them. I want to draw to your attention, sir, that between 2011 and 2021, and this is subsequent to this assertion from the Barbados Fair Trading Commission, the records show that dividends went from 15% of income to 86% of income. And I speak, sir, in dollars terms of dividends of $538 million out of 635 income. If that, sir, does not bring into question prudence, I wonder what does. So the actual fact of the situation is that current electricity rates in Barbados are too high. It is common knowledge that by installing a PV system on an individual's property, it is possible to reduce electricity costs by as much as 50%. I'm not going to spend a lot of time showing how that is established, but even Emera Caribbean Renewables themselves, a company owned by the same investors in Lightning Power, have been pushing the narrative that it pays ordinary people to get a loan and invest to bring down their electricity costs. This means, sir, that electric energy is currently available to customers in Barbados at approximately 50% of the current BLMP rates, according to market forces. Rather than review their traditional, outdated, monopolistic approach and radically embrace the new technologies to make these cost benefits of sustainable technologies available to everyone in Barbados, as sir is outlined in the Barbados National Energy Policy, what this company has chosen instead to do is to prolong their antiquated, fossil fuel-based approach and to seek instead to increase rates primarily in order to maximize cash dividends for their shareholders, who, I remind you, sir, have never invested a single cent in the company to date. So based on current existing renewable energy market competition, including competition from BLP's investor-owned Emera Caribbean Renewables, current electricity rates in Barbados are already significantly too high. It seems, therefore, to us in the coalition that it presents a conflict of interest for Emera-controlled BLPC to seek to raise electricity rates even higher, which then facilitate the renewable company to better entice customers to leave the national grid in favor of cheaper alternative electricity. Sir, the true role of a regulated electric utility is to bring economies of scale to bear for the benefit of all customers. It is not to drive customers away from the utility and into the competition, which in this case, sir, is also owned by the same shareholders. The Utilities Regulation Act empowers the Commission to exercise wide discretion in ensuring that the public good for which this company was created will be served in the interest of all Barbadians. It is clear that the lack of effective representation of other critical stakeholders, such as customers, government, and ordinary citizens, at the decision-making levels of this company has compromised that utility's ability to champion the cause for which it was created. The Cooperative Coalition calls on the Fair Trading Commission and on government to take immediate steps to ensure that this deficiency is addressed. Sir, there is no coherent case whatsoever that has been made by the company to justify any increase in rates paid by customers at this time. Indeed, a number of critical, questionable financial actions have called into question the very motives of the directors of this company at this time and clearly indicate the need for the Fair Trading Commission to use their power to claw back and to make correction to some errors that have been made. Some of the questionable actions I refer to include that $100 million withdrawal from the self-insurance fund in 2016 that was taken unpaid to shareholders. I put it to you, sir, that transaction contravenes the laws of Barbados. That self-insurance fund is set up under a trust under the laws of Barbados. I will read Regulation 8 of that trust. It says, the fund shall only be utilized by the company for the purpose of replacing or reinstating the self-insured assets which are damaged by catastrophe and reinstating the financial loss following such damage. In other words, this fund was created to protect Barbados. Nothing in there allows it to be used as dividends. And despite the assertions of the legal representative of the company, I challenge anyone to go against that, and we will be taking this further, I must tell you, Mr. Chairman. But of course, I know that you will actually address the matter. The other issues that need to be looked at, so Mr. Chairman, is the compensatory refunds that are due to customers who were forced to pay millions of dollars in additional fuel charges as a result of the delay in installing efficient plant as promised to the FTC in 2010. That is a clear dereliction of duties. Barbadians paid $3.75 billion in fuel charges during the period as a result. We estimate that could have been $1 billion less, Mr. Chairman. In conclusion, Mr. Chairman, it is our submission that not only must the Commission reject this unsubstantiated request for a rate increase at this time from already overcharged customers given the existing market, but it must move urgently to claw back the major financial missteps that have been taken to transfer funds from the Barbados Light and Power Company to its sole shareholder in the form of dividends, and which have clearly come to light during these hearings. The Barbados Light and Power Company is too important an institution, and the FTC must restore this important public utility to its rightful role in taking Barbados towards the outstanding vision established by our Barbados National Energy Policy. Thank you very much, Mr. Chairman.
Okay. Thank you, Lieutenant Colonel Brown. We'll now take a 30-minute recess. Good afternoon. Now invite the applicant to reply. You have 15 minutes.
Chair, I do not believe I need bother the commission with a reply. I believe the substantive points made in the opening addressed any and all of the comments made by the interveners. We rest our case in this matter.
Okay, thank you. Well, okay. At this time, I would like to thank all persons who have participated in this hearing. We have the applicant. I'd like to thank the interveners for their participation. I recognize the hand of Public Counsel.
Yes, sir. I just wanted to raise probably a housekeeping matter in connection with your ruling that applicant's counsel would be able to do a written, if you call it a written response to the affidavit of Mr. Smith. I just wanted to know what is the time frame within which he's expected to do that, because I would assume then I would have a right to reply and then do my written submission as well. So I'm just wanting to know what exactly is the ruling. Is it that he will send in a written response, or is it that he's sending it in his written submission? What exactly is the ruling? And if so, what time does he have to do it by?
Okay, October 28th in your written submissions is the date for the submission of your replies. So, as I continue, I said I would like to thank all of the interveners who would have participated in this hearing. It's the applicant have presented its application, and under the Fair Trading Commission and its regulatory acts and things like this, it gives the public of Barbados and several persons the opportunity to make their interventions in relation to the proposed rates. So we would therefore want to thank the Barbados Renewable Energy Association, represented here by Mr. Worm, the Energy Division, the Ministry of Energy and Business Development, the participation of Ms. Cummins and Mr. Haynes, the interventor team of Watson and Simpson, Tricia D. Watson and David Simpson, Mr. Kenneth Went and his colleagues, the Barbados Sustainable Energy Cooperative Society Limited, represented by Lieutenant Colonel Brown, and of course the Ministry of Energy and Business Development that was represented by Public Counsel, and the Barbados Association of Retired Persons, represented also by Public Counsel. So we thank you for your participation. We thank the witnesses for amplifying the evidence that they have supplied to the Commission, and we will now consider all of the material that is properly placed before the Commission. As we indicated, the interveners you could submit further written submissions, and the deadline for that is on October 28th. Okay. With that being said, once again, I would like to say thank you. I'd like to thank the press, thank the public who have attended and participated in these hearings. So I'd like to thank the Commission staff who continues to assist the panel in this hearing. So with this being said, we stand adjourned.